Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today, in the series of company law, let us learn about meetings of a company. What are the different kinds of meetings? What is this meeting? There are three different kinds of general meetings of a company. One is statutory, annual, and extraordinary meetings. Every general meeting of a company requires 20 days of notice in writing, and a private company is not required to hold a statutory meeting. So out of the three meetings, a private company can hold only annual meeting and extraordinary meetings, whereas a public company can hold all three different meetings. They are statutory, annual, and extraordinary meeting. Coming to statutory meeting, every public company limited by shares and limited by guarantee and having a share capital must hold a general meeting of its members to be called the statutory meeting within the period of not less than 1 month and not more than 6 months from the date at which the company is entitled to commence its business. And at least 20 days before the date of meeting, the board of directors must forward to every member a report called statutory report along with the notice of the meeting. And the statutory report must state that how many members, how many number of shares are allotted, what is the total amount of cash received, an abstract of all the receipts and payments by the company up to date within 7 days from of the date of report and balance in the hand. It should also mention the estimation of preliminary expenses and any commission or discount paid on shares and debentures, the names, addresses, and occupations of the directors, auditors, and also the managing agent, secretary, and treasurers, managers, and secretaries of if any of the company, any changes which have taken place in the names, etc., since the date of incorporation, that also should be mentioned. And the particulars of any contract, any modifications should also be mentioned. The extent to which any underwriting contract has been carried out and the reason should also be mentioned. And any arrears due on calls from director, that should also be mentioned. And the particulars of any commission on all the brokerage paid or to be paid by the director should also be mentioned. All these should be mentioned in the statutory report. After all these things reported in the statutory report, the report must be certified as correct by at least two directors. One of must be a managing director if there is, and it must be certified as correct by the auditors of the company. And a certified copy must be filed with the registrar, and the list of members showing their names, addresses, and occupations together with the number of shares held by each shareholder must be kept in readiness and produced at the commencement of the meeting and kept open for inspection during that session. And the members may discuss any matter at the meeting related to the company's information arising out of the report, and also if the meeting is not held or the report is not filed with the registrar or a contributory, may after the expiration of 14 days of the day when the meeting ought to have been held, applying for the winding up of the company. The court may order the winding up all to the directors for holding a meeting and filing the report, and order the payment of cost by any person who is default to those persons who have not paid. Coming to annual general meeting, this meeting is held both by the private limited companies and public limited companies. And according to section 96 of the Companies Act, every company should hold at least one annual general meeting once in a calendar year. And that is the reason it is called as the annual general meeting. And the first meeting should be held within 9 months from the date of closing of the financial year. And the rest of the meetings which happens every year should be held within a period of 6 months from the closing of the financial year, and the gap between the two must not exceed 15 months. And the meeting should be held in the business hours only, that is from 6 a.m. to 6 p.m. and it should not be a national holiday, and it should be held at a place where the registered office of the company is located, whether it is city, town, or a village. And the registrar will not excuse, and if they want to extend, the company wants to extend, they can extend a time of 3 months only, but for the first annual meeting they will not extend any time. And if there is for not holding any such annual general meeting, the penalty will be imposed on the every officer who is in default of that result of not holding the annual general meeting. A leading case law regarding for non-holding of a annual general meeting Sri Meenakshi Mills Company versus Assistant Registrar of Joint Stock Companies. In this company, a meeting was held in December 1934 and it was adjourned in March 1935 and then held. There was no meeting held in 1935. The actual annual general meeting was not held. The next meeting was held in February 1936. The company was convinced for not holding an annual general meeting in 1935. So the tribunal has imposed that in fine. Because the meeting was held in March 1935 was the adjourned meeting of 1934. So, an annual general meeting may be called by giving not less than 21 days prior notice in writing. However, a notice of less than 21 days served on a shareholder will not invalidate the meeting and the proceedings of the meetings. Besides, an annual meeting may be called on shorter notice also if it is agreed by all the members entitled to vote in the meeting. Every annual general meeting must be called for at any time during the business hours only if it is not a public holiday. Coming to the consequences for not holding. If a company fails to hold the annual general meeting, then the tribunal may charge a fine which may extend to 1 lakh rupees, and in the case of continuing the default further, it may extend to 5,500 rupees for every day until the default continues. So why is such importance given to annual general meeting? Because in the annual general meeting, shareholders can exercise the control over the affairs of the company. Any re-elections of the directors can be held. Annual accounts are presented at this meeting for the consideration of shareholders, and they can ask any questions relating to the account. And at this meeting only all the dividends are declared. So that is the importance of annual general meeting. The next general meeting is extraordinary general meeting, which is other than the statutory meeting and annual general meeting, which is held both by private limited companies and public limited companies. Every general meeting other than the statutory and annual general meeting is extraordinary general meeting. It is usually held by the directors for transacting some special or urgent business which has to be done before the next annual general meeting. So section 100 of the Companies Act 2013 provides for calling of extraordinary general meetings. Usually it is held for transacting some urgent or special business which cannot be postponed or awaited until the next annual general meeting. It is held on the requisition of the members having at least 10% paid up capital. If they don't have the 10% paid up capital, then 10% voting power at least should be there. Usually it is held by the board of directors or on its own or the requisition of the members, or else if they requisition themselves on the failure of board of directors for calling the meeting. As such, we have come to the end of the session. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe. Thank you.